Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated. Case number 20-5008 et al. American Forest Resource Council versus United States of America et al. Soda Mountain Wilderness Council et al. Appellants. Mr. Toad for the federal appellants. Ms. Boyles for the appellants Soda Mountain Wilderness Council et al. Mr. Bechtold for the appellees American Forest Resource Council et al. Mr. Remfjord for the appellees Association of ONC Counties et al. Ms. Weiss for the appellees Starfire Lumber Co. and South Coast Lumber Co.
Morning.
May I proceed, Your Honor?
Yes.
May I please the court? As this court knows, this set of appeals arises from disputes concerning approximately 2 million acres of federal managed land in the Pacific Northwest that has been managed for decades with an understanding that there is a balancing process when it comes to applying multiple statutes that dictate the management of the complex set of natural resources in this region. The district court here, through the ruling, erroneously disrupted that settled understanding of how these lands are managed. And that settled understanding has been assented to by Congress through a series of amendments. And the district court here erred in many respects that we outline in our brief, but I'd like to focus my presentation this morning on one overriding theme, which is that the district court failed to rigorously impose upon plaintiffs.
Could you move a little closer to the guy there?
The district court failed to rigorously apply plaintiffs their heavy burden under EPIC systems to demonstrate a clear congressional intent that the Oregon and California Lands Act displaced the government's other responsibilities under other applicable statutes. The court's failure here stems from three different components of the analysis: the statutory text, the statutory history, and finally the congressional enactments that demonstrate Congress's implicit assent to the way that the Secretary of the Interior and the President have been managing these lands for decades. Before I turn to those argument points, I'd like to just provide a little bit of context for why this is such an extraordinary set of cases. The district court's decisions were unprecedented in three different respects. As to the monument challenge, this is the first time that a district court that we know of has ever issued declaratory relief against the president in validating presidentially proclaimed national monuments. The Antiquities Act it was enacted in 1910. It's been on the books for over 100 years, yet this is the first district court to invalidate a presidential proclamation of a national monument. As to the plan cases, this district court decision is unprecedented because for over 25 years, with the approval of the district courts in the Western District of Washington and the District of Oregon, as affirmed by the Ninth Circuit, there has been a management regime in place known as the Northwest Forest Plan Amendment. And that has been accepted as a compromise between timber industry and environmental interests. It hasn't always, sometimes it works out to the benefit of one side or the other, but it has been understood to be a settled balance for land management. And again, the district court disrupted that settled understanding, contrary to the only court ever consider the question of whether the ONC Act and the reserves on the plan managed land can be reconciled. And then finally,
when you say the question is whether the ONC Act has displaced other statutes, don't you have it in reverse? It's whether this proclamation under the Monuments Act has displaced the ONC Act. That's been in existence since the 30s, so it's not displacing anything. The question is whether it's being displaced.
Well, I think you could look at it either way. The way I'm seeing it is the president exercised the authority under the statute that existed before the ONC Act. And so you have to look to, and I don't know that the timing necessarily dictates the outcome, because we have statutes that were passed before the ONC Act. We have statutes that were passed after the ONC Act. I think the fundamental mode of analysis is to look to whether plaintiffs have met their clear burden of demonstrating that the statutes are.
what's the statute other than the Antiquities Act? And it's not the Monument Act. I get them all
For the
thrown
plan
together.
case,
But what's another statute that has, I mean, the Antiquities Act is older than the ONC Act. What other statutes are you talking about that are more recent than the ONC Act?
for the plan, they're relevant to the plan cases, not the monument cases directly, but the
Okay.
Clean Water Act and the Endangered Species Act.
Oh, okay.
Later enacted, but still, I think the timing is useful to look at. Certainly, when turning to the monument case first, I think there's a clear path to reversal in that the Antiquities Act expressly confers powers on the president himself. The Oregon and California Lands Act doesn't mention the president at all, and you would expect that if it's going to take away those expressly delegated powers, which my friends on the other side point out stem from Congress's exercise of its property clause authority, it lawfully delegated that through the Antiquities Act to the president. You would expect that if Congress intended to take that back, they would mention the president in Oregon and California, and they don't. But that sets that case apart from the plan challenges in Wisconsin, and is a way that shows that the statutes can be reconciled, and therefore under ethics systems, they must be.
So I understand your position to be that a president's action under the Antiquities Act is not reviewable. And how do you square that with the Reich case?
So the Reich case involved the two different, the executive order under the Procurement Act by the president, and then it was held to conflict with the National Labor Relations Act. The government argued there that the statutes did not facially conflict, and that was the distinction. We would say it's the same distinction here. There is no facial conflict between the mention of the president in the Antiquities Act and the Oregon and California Lands Act. So we recognize that the government lost on that argument under those different statutes in Reich. We think here it's an easier case, that it's not an easy case, but it's an easier question. Even applying the framework in Reich, there isn't a facial conflict between the Antiquities Act and the Oregon and California Lands. They can be reconciled. So it becomes a matter of how much.
So in your view, could the president designate the entire ONC land tract as a monument?
I think that would be an irreconcilable conflict, just on the facts. If those were the facts pleaded, I assume that, the proclamations here announced the acreage, right? So we would expect, there'd be publicly known on the face of the proclamation that in that hypothetical, they designate the entire acreage. That seems to be an irreconcilable conflict. The Oregon and California Lands Act deals with an entire set of lands. It stems from this remedy that was given to the counties for violation of these original grants to the railroads, where they didn't give away the land on the terms that Congress had instructed.
But that would make it reviewable. Just saying the result would be an irreconcilable conflict. Don't we have to review what the president did to determine if there is a conflict or not? I
think that's the dilemma, and that's why there aren't a lot of cases that squarely address this. It doesn't seem like the Mountain States case or the Tulare case. There's a little fuzziness to the analysis because of the overlap in the merits question and the reviewability question. But I think where you are here is trying to judge whether the amount of acreage that was set aside is too much, and that's in the monument. And I think that's a question of the exercise of the president's discretion that is not reviewable under Franklin and under Dalton.
But why isn't it just reviewable, but it's reconcilable once we review it?
We recognize that we're bound by Reich. I think applying Reich, we don't think that the proclamation here is, that facially conflicts with the Antiquities Act. We would just rest on that argument. I'm prepared to speak to the merits. I recognize that this court has considered presidential actions in the past. The Supreme Court has notably never squarely decided to resolve this question. So we noted here to preserve it. But if I could turn to the merits a little bit more, not only does the Oregon and California Lands Act not expressly mention the president, but as relevant to both the monument cases and the plan challenges, the statutes can be harmonized. The Oregon and California Lands Act has in its text a lot of places where there is discretion in the wording. And I don't think the district court rigorously looked at the text as the court ought to determine whether there was any play in the joint, which is really all that's necessary for there to be discretion that's, subjects the Secretary's allegations to the Endangered Species Act, for example, or the Clean Water Act in the plan cases. I just wanted to highlight three features of Section 2601 of Title 43, which is the main text we're talking about in both the plan cases and the monument cases. The first feature of the text that provides discretion is that the lands are referred to as those that may heretofore or may hereafter be classified as timberland. So there's some discretion whether to classify the lands as timberlands in the first place.
Do you read that to mean, I read or may hereafter, not to shrink it, but to expand it, the classification of timberlands?
So, I'm sorry.
Which may be classified heretofore or hereafter. It doesn't say may be classified here before or hereafter reduced, or
I think there's a recognition that the classification process could be looked at later, not just that it's retrospective.
I agree.
And I don't think that, maybe the statute doesn't speak to this. Maybe maybe the statute is silent on specifically on revisiting classifications. I mean, it might not mention it expressly, but I think it's fairly implied that if it can be classified later, that classification may change. After all, they are going to
reduce.
Well, I mean, they're going to be cutting lands, right? And so the question is whether Congress is very concerned about keeping these lands productive in the long term. And this dovetails with the statutory history. The statute was passed to move away from this clear-cutting regime where the timber was just being liquidated for the benefit of generating revenue for the counties. And that was, one, not generating enough revenue, but two, it was only generating revenue in the short term. So Congress had, when it passed the 1937 Act, it moved away from that liquidation regime to a sustained yield management regime. And so that's the second feature of the statute here that provides some discretion. The classification, I think, demonstrates that there's authority to look at the lands and to decide which ones are suitable for timberland. So that necessarily defeats the district court's assumption that which I think underlines its orders, that every single acre of these 2 million acres, if it's timberlands, had to be cut. So I think that the fact that...
what's the second point of discretion in the USCA Act?
It's the sustained yield, the reference to being managed for permanent forest production and the timber being sold, et cetera, in conformity with the principle of sustained yield. And this notion of sustained yield sort of embodies this concept of the government being a steward of the resources. It's to get away from this prior liquidated timber regime and to have a forest, what is essentially a forest that can be sustainably used in the long term to produce timber, to generate revenue, and to achieve these other purposes that the statute goes on to talk about after talking about sustained yield, that I think do inform the understanding of that term, protecting watersheds, for example, providing recreational facilities, contributing to economic stability. All those concepts provide a room for both the president to take a small fraction of the lands, the overall lands. We're talking about...
I want to get back to the classification point, because in 1916, the definition of timberland reduced down to 7,500 board feet per acre. Is that correct? It's for the 40 acre, it was 300,000. I think that's 7,500 an acre, which is a very dense forest. And my question is, in 1916, I imagine the forest in Oregon was just as dense as it could be. Is there any area of the ONC land that still meets that? I realize that the 1937 Act repealed, in part at least, the 1916. And the only definition of what is timberlands that I could find was this 1983 classification used by Interior for timber production capability. So can you tell me what it is now that defines timberlands? How many board feet per acre?
I don't know the exact criteria offhand. I'm familiar with
Do you
that.
know if it exists?
They do have criteria, and they're similar, I believe, to the ones that you just read. My point about the classification is not so much that classification is the way that the government segregated the lands here, either through the monument or through the reserves and the plans, but only that when you're looking at the statute and you see that it provides the Secretary discretion not to harvest timber on every single acre, be it according to that technical definition or be it according to these other broader concepts like sustained yield, that is enough discretion to defeat this notion that the statutes are irreconcilable.
In your view, is the default that the land is not timberland? It has to be affirmatively classified as timberland to be timberland? Or is the whole thing timberland unless it gets reclassified as something else?
I think it's the first, that it had to be classified. And I don't want to get too bogged down in this. I think it demonstrates, I think, that not every acre had to be harvested. It also indicates that there's some further discretion that the Secretary was able to exercise too. I want to emphasize, and I'm well into my rebuttal time, but I want to answer the court's questions as fully as I can. I'd like to just briefly highlight Congress's activity in this area. And I think this is something that's important to construing the statute that the district court just ignored or disregarded altogether. And it's that Congress has been very actively engaged in essentially a dialogue with court rulings that come out in this area, with the actions of the Secretary of the Interior that have come out, with the President Clinton's original proclamation of the monument. And Congress has assented to through enactments such as the
Well, you're getting into acquiescence. Right?
I'm sorry?
Are you getting into congressional acquiescence?
Yes.
Well, my colleagues may disagree. I don't think you meet those criteria at all.
I guess I would just highlight that there is a legal backdrop that Congress has been actively engaged in, and where it is wanted to adjust monuments, where it is disapproved of monuments, it has adjusted boundaries. It has taken land out of federal ownership altogether. It has changed the configuration and given lands to be managed by other federal agencies. We cite a number of examples of this in our reply brief on pages 7 and 8, footnote 2.
Well, I mean, your point is not technical acquiescence. It's that Congress has never acted to disrupt the fluidity of the situation that we're looking at over the years. That's your principal argument, is this has always changed over the years. And the nature of the timber, how much can be harvested, et cetera, has never been static. And Congress was sitting there and watching it, and they never interposed any objection that would change that. I thought that was your argument.
That's right. And
so it doesn't matter whether it's formal acquiescence. It's what's obvious. Congress has never disrupted the process of the president being able to proclaim and the secretary being able to act pursuant to 2601. I thought your principal objection on 2601 is the district court just gives it a clipped reading. The district court talks simply about, gives a weird reading to sustained yield, and then ignores everything after timber supply, ignores protecting watersheds, regulating steam flow, contributing to economic stability, and providing recreational facilities. That's in the statute that the other side's pointing to. Those are all the goals. It's not just timber supply. I thought that was what you were, because when you see some of the district court's decision, it just ignores the rest of 2601, as I recall.
Yes, that's a fair summary of what the district court did. I think the congressional enactment, and yes, and the text is where the court started. The district court did not consider the entirety of it. I recognize I'm into my
All right, we'll give you some time. Ms. Boyles?
Morning.
Morning.
May it please the court, my name is Kristen Boyles and I represent the interveners, Soda Mountain Wilderness Council this morning. We are defendant interveners in only the monument cases today. And I have about 3 points to continue the conversation that you've been having with Mr. Toth. And let me move to the first one, which is taking off where Judge Edwards, where you just were, this question of irreconcilable conflict. And in fact, Judge Pan, you asked as well. There is no irreconcilable conflict between these two statutes, which is what you need to do to find in order to find an implicit repeal. The statute talks about, the ONC Act talks about permanent forest production. Doesn't talk about commercial timber, doesn't talk about commercial timber production. It talks about forest production. And then the act itself goes on to show that it's about more than just the trees in the forest. It is about the 5 goals that the Sustained Yield Act is supposed to protect. And those goals are timber, yes. They are protecting watersheds, regulating stream flows, sustaining, helping to contribute to economic stability of these communities, and providing recreational facilities. And the district court below erred by saying shall means shall and not reading the rest of the sentence and not reading the rest of what the act requires. That shows that this actually, the ONC Act of 1937 is much more of a conservation and land management statute than the timber interests would have you believe. This is the other point to make here in response to some of my opposing counsel is that the proclamations themselves do not prohibit commercial timber harvest. It is severely curtailed, absolutely, but it is not prohibited. It is allowed if there is a sustained science-based ecological restoration project, which is, as forestry has evolved over the years since 1937, essentially the same sort of science-based forestry management practices that the 1937 Act was envisioning. This protection of all of the values of the forest, not just
Is it
trees.
in the record how long it took for the other objectives to be pursued other than timber?
How long?
How long it took from 1937?
If I understand your question, Your Honor, it is. These are all of the goals that the agency is supposed to do going forward.
Have the streams always been protected? Have the the ESA Act didn't come along till later. Was anybody concerned with these other projects before ESA, clean water, all of that?
So yes, Your Honor. I don't know.
Does the record show that? That's all I want.
The record shows that the agency, BLM here, has been acting to use its discretion about the volume of timber and the way it manages those lands since 1937.
Okay.
It is not said every acre, every timber sale has to go forward. That is not its position. It's been quite discretionary. And of course, later acts, as you know, come in and provide even more requirements for the agency, because it's not unusual for federal land to have multiple laws apply to it.
Let me ask one more time.
Yes.
Does the record affirmatively show that from 1937 on, BLM affirmatively pursued the other objectives other than timber?
I believe it does, Your Honor. I will point you to 2 places in the joint appendix. That's
right.
Joint appendix at 810, starting at 810, and also starting at page 827. Those are 2 solicitor memos from 1981, and I realize that's not the time frame you're talking about, but that has the history. Those 2 memos have the history looking backwards,
okay.
And I think that can help answer that question. I just also want to mention that because there is no clear and manifest intent for Congress to repeal this law, you need to find that intent or the irreconcilable conflict in order to imply a repeal. There's nothing in the Antiquities Act that talks about, there's nothing in the ONC Act that talks about the Antiquities Act. Congress did repeal laws in the ONC Act. It knows how to do that when it wants to. It repealed the Chamberlain-Ferris Act and another public land law. And on the issue of not acquiescence, Your Honor, but on Congress's recognition that it doesn't need to step in here because there's no problems, Congress has funded the original monument, which contains ONC Act lands for the last 2 decades, and approved planning processes for it. It has funded voluntary land exchanges and grazing lease buyouts within the original footprint of the monument. And when the Antiquities Act was recodified in 2014, Congress did absolutely nothing to indicate that there was a problem with ONC Act's lands being part of a monument. For those reasons, Your Honor, we would respectfully request that you reverse the decision of the district court and confirm the Cascade-Siskiyou National Monument.
Thank you. Mr. Bechtold? Since you're with the American Forest Resource Council, can I just ask you, is there any acreage left that fits the definition of the 1916 Act without regard to whether it still applies?
May it please the court. You did pick up correctly that the 1916 Act goes back and looks at how many board feet an acre can grow. That's a very common thing we do in forestry. Right. What you most likely see it done is a forest typing.
Can you move closer?
Where you would look at the soil type, look at the fertility of the soil, how much rainfall falls in place, what the elevation is.
Lift the podium up, please. There's a button there. Bring the mics forward. Our mics are...
Looks like as high as it's going to go. Apologies. I don't know the exact acreage that meets that, but 300 board feet for 40 acres is not a very high level, given the amount of rainfall we receive.
300,000.
300. It's 300 million board feet, as I believe was in the 1960s. That's not an extremely high number. You would look at soil contents, rainfall, elevation. Essentially, what we do on commercial timberland is you have site classes. They have site classes for BLM too. BLM could look at the site classes, the timberlands out there, and determine it. Can't represent to you exactly how many acres fall into which site class out there, but an awful lot of this is going to meet that definition. No questions asked. The law was written in 1937 very intentionally to ensure that timber was harvested from places that are considered timberlands, just like croplands are those lands that are best suited for the growing of commercial timber.
What I'm curious about is the density of the forest now as compared to 100 years ago. Are there still parts of that forest that are as dense as they were 100 years ago?
I'm sure there are places, but that definition isn't going to standing volume. What that definition is going to is the ability of the land to grow timber. So sustained yield timber management is some percentage of the estate you're harvesting, some percentage of the estate you're replanting, and some percentage that the estate you're regrowing. And as you get those stands to a mature level, you harvest them. So when you're classifying a timberland based on board feet, you're classifying those lands based on the potential to grow this amount. So just like if you're harvesting corn, how many bushels of corn can you grow on an acre? It's not how many bushels of corn you have in May, it's how many bushels of corn you have in September. And so what that definition is saying is if you put these lands on a sustained yield management track, you harvest, replant, and regrow in perpetuity, are those lands going to get there? And the answer is yes, those lands have the same potential to grow timber today that they did back in the day. There are probably places that have those volumes, those stocking volumes that are being harvested. There's probably areas that were harvested last year that certainly do not have those volumes, but they will in 40 or 50 years.
There are other interests we have to take into account, making the determination as to how much to harvest.
Yes, that is what sustained yield management is about.
And that's what 2601 says. That's what the Clean Water Act says. That's what Endangered Species Act says. There are other lawsuits going on where other statutes are being enforced, which will affect how Interior looks at what's available for harvesting, right?
Yes, but I think we need to go back.
How well things are growing or not growing. It's no clear number. You don't know that there's a clear number that's going to be there each year. You have to take all of these factors they have to take all of these factors into consideration, right?
At the moment of classification of a timberland, but the moment they define something as a timberland, at that point, it has to be put into the management bucket, the sustained yield management bucket. And what they're doing here is they're never making that determination of a timberland, particularly as it goes to the Antiquities Act. They're just saying, let's take these lands and set them aside. They're never making any determination about a timberland. And
To serve statutory interests. They're setting them aside. And it's not a whimsical set aside. It's set aside pursuant to acts of Congress and the presidential determinations that have been made, right? You may not agree with those determinations, but it's not someone just saying, oh, let's just set aside.
I wouldn't agree with that because
You wouldn't agree with what?
I wouldn't agree with the notion that these lands are set aside, particularly in my case as a monument. What the president has said is, I want to set these lands. Specifically, what he ordered was, and I'm going to read from 65 Federal Register 37249, which is Proclamation 7318, which is the management mandate. It specifically says, no portion of the monument shall be considered to be suited for timber production, and no part of the monument shall be used in the calculation and provision of a sustained yield of timber. What he's doing is he's taking the Antiquities Act, saying, I want to create an ecological reserve, and so I am going to completely write off the ONC Act's mandate to put these lands into sustainable yield management. There's no balancing there as it comes to the monument.
But why can't it be that that part is not classified as timber under the ONC Act, and therefore the two acts are reconcilable? It's a monument, and those parts of it that would have been ONC land are just not classified as timber under the ONC Act. And it's only 2% of the 2 million acres that are covered by the ONC Act. So what's the problem?
Two responses to that. First, the president never made a determination. He decided this was a national monument. He wanted to make a national monument. He said nothing about timberland. Second, if they were to make a determination of timberland, they would have to go back to exactly what Judge Henderson said. They'd have to go back to the definition of what a timberland is. They can't come up with a definition of timberland that
It's not about defining timberland. It's about classifying as timberland, which the secretary has discretion to do. We said so in our Clackamas case.
I think that discretion is much more limited, and it's limited by the exact definition that, again, Judge Henderson pointed out. It refers back to the Act of 1916.
Wasn't that repealed? The 1916 Act was repealed by the 1937 Act.
But it's the only place it references back to it. It repeals it, but it's in the same policy. And again, even if that definition doesn't apply, let's look at the policy of the ONC Act. The policy of the ONC Act is to generate continuous streams of revenue for counties.
But you have 98% of it left. You can still classify whatever you want on the remaining 98% as timberland. And I just don't see, isn't it our job to try to reconcile what the president did under the Antiquities Act with the ONC Act? And doesn't this reconcile it?
I don't think it does. Think about it this way. So say I endow a scholarship fund for $1 million, and I say these should go for underserved Oregonians to college. And I give it to the university. The university says, I'm going to spend $50,000 to update my quad. And they say, don't worry about that. It's just a small amount. At the end of the day, somebody's still holding the bag. And in this case, it's the counties. We have set up.
But what if you gave it to them and said, you have discretion to use this as you will?
I don't see that discretion. I see the ONC Act.
The ONC Act says classified as timber. Somebody has to classify as timber.
That is correct.
Not all the land is timberland if some of it has to be classified as timber.
And that classification has to be reasonably related to the purpose of the act and also the general understanding of what is timberland. And so if you have a forest that's growing that is generating volume for a community, and you decide, I don't want to call that a timberland, not because it's not a timberland, but because I don't want it to be cut down on, I don't want it, I'm out of time.
Go ahead.
I can finish if you want, but I do think there has to be a standard as to the timberland. We can't just ignore it and ignore the policy and say something else.
Who gets to decide what's the standard as to a timberland?
In the Antiquities Act, no one ever made that decision.
But no, in the ONC Act, it's the secretary. It's the agency. They have discretion to classify lands as timberlands.
And I think that there has to be a rational basis to do that. And if they diverge from that rational basis, it's up to the court to look at and define what is a timberland. And I think in that case, just to say it's a timberland because we don't want to harvest it. It's not a timberland because we don't want to harvest it. Is arbitrary and capricious.
That's all they said. What record are you looking at?
Well, I
That's all they said. We're not going to harvest it because we don't want to.
So
I may have missed the record, and it's okay if it's there. You need to point me to it. That's all the secretary said. My decision for not harvesting is because I don't want to. That's it. You can't be serious.
So I
know you're an advocate, but that's an overstatement in the extreme. That's not what the secretary gave justifications for why the position was reached.
I wanted to draw a classification between my case, which is the monument case, challenging presidential action, and Mr. Ramsford will get up here in a second and address some of these other issues as to the set-asides and reserves in the plan. But as to the monument, that is a unilateral presidential action in which he sets lands aside in violation of the UNC Act without making any determination under the UNC Act at all. He just acted under the Antiquities Act on his own. There was no independent analysis.
Does the Antiquities Act give the president that discretion to act?
The Antiquities Act.
You don't like it, but does it give it?
The Antiquities Act does not give the president the authority to violate other acts of Congress.
Okay.
Right.
Gotcha.
Thank you for the additional time.
Mr. Ramshorn?
Please support. My name is Harry Ramford. I represent AOCC and will be asking you to affirm the plan case on behalf of all police. I want to start by addressing this issue of classification. I think there's some confusion there. The government claims that the Act gives BLM discretion to classify lands as timberlands or not, thereby suggesting that it can classify them for some other purpose, like creating reserves. That is not so. BLM's discretion to classify lands is actually governed by a statute. The ONC Act itself refers back to the Act of June 9, 1916, which allowed the land to be classified into three different types of property. Power site lands valuable for the production of water power, timberlands, which were, as Judge Henderson noted, lands capable of producing 300,000 board feet of timber or more on a 40-acre parcel, and agricultural lands, which are the remainder. The Act of 1916 does also refer to the potential of reclassifying lands, but only to bring them in their true character. And as to Judge Pan's question on whether or not the Act of 1916 was totally repealed, it was not repealed in part. The way in which the land was managed under that Act was changed by the ONC Act. So there is not this broad discretion to simply reclassify lands for another purpose or for the creation of reserves. And we disagree with that. With respect to some of the questions regarding the language of the ONC Act, the government claims that it has discretion to create reserves because the ONC Act provides that the mandate to produce timber on a sustained yield basis is for the purposes of providing a permanent source of timber supply, protecting watersheds, regulating stream flow, and contributing to the economic stability of local communities, and providing recreational facilities. This language, in our view, really describes the benefits of sustained yield management. It does not displace the mandate itself to manage land for permanent forest production and sustained yield.
The language says sustained yield for the purpose of, and then it lists those purposes.
It does, but
That's not saying the end result will be if you cut timber, then all of the rest will follow. It's saying the purposes that you're aiming for are what you just cited.
But the Act also talks about the fact that you measure the annual productive capacity for such lands. You determine that each year, and that full annual productive capacity is to be sold annually, or so much thereof as can be sold.
Right. But these other purposes are still in play.
Those other purposes are still in play, but they're described largely as benefits of managing on a sustained yield basis. They don't displace the fundamental.
The sustained yield for the purpose of, and then it lists the 6 things.
It does.
All of them are things that should be taken into account when you determine what the timber production is going to be.
Well, those are actually.
Is your argument that anything that grows should be cut down, and if they don't cut it down, they violated the Act?
Oh, that's not how sustained yield works.
Yeah, I know. I didn't think so, but I'm trying to understand what your argument is. So what else is taken into account? any healthy tree out there should be cut down?
No.
Don't think about anything else, just whether they're healthy trees.
Your Honor is absolutely correct. The UNC Act is different from the prior acts, which were outright liquidation. Anything that can be cut
That's
down
exactly right.
down.
That's the history.
That's the history. You change the sustained yield, which is you have a principle, you have a forest, and you keep that forest in place, and as there's new growth, you take it off. It's like interest on principal in a bank.
And you take nothing else into account. It's
you
just,
don't?
you look at the quality of the growth, period. That's what that statute says.
That's what you say, that's what sustained yield means, but that will
What
provide.
sustained yield is followed by for the purpose of, it gives meaning to sustained yield, and there are a number of purposes in there, and I assume the secretary has the discretion to take all those into account.
Well, those are things that will result from management
Yeah, well,
sustained
that's,
yield.
I didn't understand your argument went that far. You're saying, no, these are just results, because if you read it that way, then timber supply is just, I'm not understanding to read it all. That's not the language. That's not what the language says.
My reading, Your Honor, is that if you manage on a sustained yield basis and you have that principle in place, you keep that principle, then you have resulting benefits. That does provide a permanent source of timber supply. That does protect watersheds. That does regulate stream flow. That does contribute to the economic viability of local communities and industries. And that does provide recreational facilities. So it does all those things. And that's exactly what BLM itself acknowledged in the final environmental impact statement to the 2008 plans, where it said, quote, it would be inconsistent with the ONC Act to treat these expected benefits as additional objectives that must be balanced against sustained yield forest management and thereby reduce the annual productive capacity that would be offered for sale. So from our perspective, that those terms can't be used to justify reserving 80% of lands for something other than permanent forest production on a sustained yield basis. And there's no dispute that these reserves, one, contain timberlands, two, are in fact reserved for different purposes. They are land use allocations described in the plan that, quote, do not have objectives for sustained yield timber production. And that's the Joint Appendix 1825 and 26 and 2145. Moreover, those lands are excluded from the calculation of the annual productive capacity that has to be offered for sale each year. And that's at 1825 and 26 and 2145. And those are the basic reasons that the district court ended up finding that the RMPs of the plans violated the ONC Act. So going beyond...
Is it your position, counsel, is it your position that the secretary has no discretion to manage these lands other than for timber production? Is that what you're trying to tell us?
That's what you seem to be saying.
And is that the only way you can win? We would have to find the secretary has no discretion to do anything but manage these lands to produce timber.
It's our position, Judge Coun, that the secretary must manage land for permanent forest production on a sustained yield basis. Within that discretion, within how you manage on a sustained yield basis, you can do a lot of different things.
Why don't you answer my colleague's question? It really is, it really leaves out. I'd really like to hear your answer to the question that she raised.
And what I'm saying is that there is discretion, in fact. There's discretion within the sustained yield mandate to regulate the rate, the timing, the sequence, the location of harvest in any given area.
So
that allows for...
I understand your answer to be the secretary has no discretion to manage this land for any purpose other than timber production, but within the goal of timber production, the secretary has discretion. Is that your position?
Yes.
And that's the only way you win. If we would have to hold the secretary has no discretion to manage this land for any purpose other than timber production.
And that is because this is a unique dominant use statute. This is not like other federal land management statutes.
But you agree with me that that's the only way you win?
Well, I think that is the way we win, and I think that it's right. I think that the statute is abundantly clear that this land shall be managed for permanent forest production, and the timber thereon shall be sold, cut, and removed in conformity with the principle of sustained yield.
And so what about the Endangered Species Act? We haven't gotten. What about the Endangered Species Act? And it's the Endangered Species Act.
Well, the Endangered Species Act came on afterwards, and
And it doesn't apply here?
Doesn't apply?
well, it does apply. It applies absolutely, but it applies in the narrow circumstances that the National Association of Home Builders case said it does. It applies to the discretionary acts that BLM can undertake. So here, for example, I mean, we don't want to say that BLM can't comply with the ESA. It can and must comply with the ESA, but only within the bounds of its discretion.
But you said they have no
Management.
discretion.
You said
I
they
did not
had
say
none.
that, Your Honor, with all due respect. I said there is discretion with location of cutting, the rate of cutting, the sequence of cutting. All of that is something that's done. Sustained yield management doesn't mean you go in and liquidate. It means you cut some here this year, you cut some there this year.
Okay, so can you explain how that would work? How would the secretary comply with the Endangered Species Act within the bounds of what you say he has discretion to do,
Sure,
or she
sure.
has discretion to do?
The secretary would go back and consult with Fish and Wildlife Service about how to develop a plan for conducting sustained yield management that included the entirety of the estate of the ONC lands.
And what if it's incompatible?
Well, we don't know there would be. and
But
it's
if
hard
it
to
were,
know.
what would happen? I'm just interested in how
Well, if
discretion
it
works.
would be, you go through the process of getting a biological opinion. There would be a jeopardy determination. You would then go through the process of
Yes, I
looking at
understand the
reasonable
process.
alternatives. Yeah. but
My
you-
question is, and what if that all shakes out and it says it's incompatible? You cannot manage this land for timber production consistent with the Endangered Species Act. What happens?
We would be in a very different position then. But that didn't happen here. What happened here was that the lands were set aside in advance. 80% of the lands were set aside before the fact, and the consultation only took place afterwards. And I see I'm out of time.
No, I want to ask you one more
Sure.
question. Do you have any authority supporting your proposition that the notion of sustained yield does not include protecting watersheds, regulating steam flow, contributing to economic stability, providing recreational facilities? Is there some authority that says that? See, you're talking about sustained yield in a way that says, I win. That's your definition of sustained yield. I'm looking at statutory language which says, I don't understand his argument. Do you have something to support your argument that these other purposes are not within the compass of sustained yield? Because I didn't see it. If it's there, I'm really happy to look at it. Where is it?
It may be that, as I listen to your question, it may be that we're just missing each other a little bit on this.
A lot.
point. Yeah, okay.
All I want is for you to point me to an authority that defines sustained yield. I want to narrow it as tightly as I can in the clipped way in which you're doing it. That's all I want. And please don't go beyond that. Just go with my limited mind. Give me an answer that I can digest easily, because you have to understand what you're doing. You stood for your 15 minutes and said, sustained yield means I win. And I win because none of these other factors are part of sustained yield. What authority says that?
Well, the term is not defined in the statute. It was discussed extensively in the legislative history. The former chief of the Forest Service described it as cutting as much timber as you can based on the annual growth while preserving the underlying principle. That's at JA 24.
While preserving what?
While preserving as much as you can of the principle.
Yeah.
That's at JA 2479 and 2497.
There any source, any case, any regulation, any statute that defines it to ignore the provisions in the statute that I'm looking at?
Well, the case that I would actually refer you to is the Ninth Circuit's case in Headwaters. And in that case, the Ninth Circuit explained that the ONC Act envisions timber production as a dominant use. It also went on to explain that, quote, exempting certain timber resources from harvesting to serve as wildlife habitat is inconsistent with the principle of sustained yield. That's at page 1183 to 1184 of the opinion. It also went on to say that doing so would be inconsistent with the purpose of the ONC Act, which the Headwaters Court found to be, quote, to provide the counties in which the ONC Act land was located with a stream of revenue, which has been promised, not delivered by the Timberland Revestment Act. So those would be the authorities that I would point to.
Okay, thank you.
Thank you. I'll pass it on now to Ms. Weiss.
All right, Mr. Toth, why don't you, oh, I'm sorry, Ms. Weiss.
May it please the court, my name is Julie Wise and I represent the appellees in Swanson, where the district court properly held that BLM failed to comply with the ONC Act in violation of the APA. Just as the court should affirm the district court's decision in the monument and plan cases, the court also should affirm Swanson both as to the merits and as to remedy. Judge Edwards, before I begin my principal argument, I would like to refer you to one thing that addresses the question about authority that might have talked about the secondary benefits as we view them from the ONC Act. And that is in 1938, when the federal government promulgated the first regulations for timber harvest under the ONC Act, it actually referred to sustained yield timber harvest would generate, quote, secondary benefits, end quote. That's found at 3 Fed Reg 1796.
The what? Say that again, your sentence, I didn't hear.
It was the 3 Federal Register 1796.
No, what did you say?
It was in 1938, so contemporaneous with the passage of the Act. And what the government did was promulgate regulations for harvest under the ONC Act.
Right.
And it said by managing sustainably, there would be, quote, secondary benefits. And it was referring to the secondary benefits like protecting stream flow and things of that nature. But that I just wanted to give you that citation. My job here is to talk about a different creature, which is a failure to act creature. And what I'm going to do, the district court found all the requisite requirements for actionable agency non-action. What I'm going to do is jump right to two Supreme Court cases that help us understand why this case should be affirmed. In Lujan, first of all, your honors, 497 U.S. 871, that case was a non-actionable programmatic challenge where the litigants said, we're challenging a land withdrawal review program. That was a name that they had created. It was not, there was no such thing, and they wanted it set aside. In reality, what there was well over an amalgam of more than 1,000 different land review classifications and land withdrawal revocations, and that was what the court said, that's programmatic. We're not going to interject ourselves into the day-to-day operations of BLM. Here, the final agency action was BLM's failure to sell or offer for sale the declared annual sustained yield capacity. So this is not Lujan. This is not SUA either.
Can I ask you about Lujan? Because Lujan did talk about the continuing and thus constantly changing operations of the BLM. And I think your issue kind of turns on whether this was a discrete act or not, right? Because the relevant provision within the APA requires under SUHA that the agency fail to take a discrete agency action that it is required to take. Right. I think we're looking at whether this is discrete or not. And here we're talking about something the secretary has to do every year, annually. And to me, that seems to indicate that's not discrete. And looking at other cases that applied this discrete standard, I was not able to find any case that applied to a continuing, ongoing, every year obligation, which also involves looking at reasonable prices in a normal market, which sounds kind of discretionary to me. So to me, there are two aspects of this that indicate this is probably not a discrete action and therefore not subject to the judgment that was rendered.
Your Honor, it does involve a discrete action, and I'll address both of your points. First of all, it is discrete because even though BLM has to make a number of determinations before it declares that allowable sale quantity, once it declares that number and it chooses to declare it in plans, that number has to be met on an annual basis. And so the discrete action is the equivalent of a rule. We have to find something that is the equivalent of something in the APA, a rule and order. It is the equivalent of a rule, an agency statement of general or particular applicability and future effect.
But the action is the sale. That's what you're trying to compel. And the sale doesn't happen until it can determine whether there's a reasonable price in a normal market. And the agency has to do it every year.
The action that we're trying to compel is compliance with the declared allowable sale quantity. It is effected through timber sales, but the challenge here is not to a timber sale program or to individual timber sales or the lack thereof. The challenge is to a failure to meet a declared ASQ. So this case did not involve a challenge to a plan. It involved a challenge to a failure to comply with an obligation under the ONC Act. Now, BLM declares the allowable sale quantity, but it was not actually putting that into effect.
Right, you're trying to compel this sale. The ASQ was declared. Now you're saying just sell that, right?
We're saying comply with the ASQ, comply with the ONC Act, because you have said this is the amount we're going to sell, and you haven't done that.
Right.
You need to do that on an annual basis.
I understand, but I think the issue is whether selling it is a discrete act. And in the context of something you have to do every year, and every year you have to, or the secretary has to determine what are the reasonable prices on a normal market, does not sound discrete.
I think Justice Scalia would be shocked to hear your interpretation of his opinion in what 706.1 means. I mean, what he was trying, if I remember that correctly, what he was trying to say was, when you come in and say, we want to compel the agency to do what it is we're saying, he said, you better be able to show me something that is absolutely clear. There's no dispute whatsoever. There's no discretion, nothing loose. One is one, and they haven't done one. That's not the case you're presenting.
Your Honor, I disagree. And
What? With my interpretation of Justice Scalia's opinion, or my interpretation of you?
your interpretation of me, Your Honor.
Okay.
And I will refer you to SUA, because I think SUA offered an interesting example, and it was a hypothetical example. There, the court said, let's look at the Telecommunications Act, where the FCC was required to promulgate regulations within 6 months. This was a hypothetical, and it said if they didn't do that, that would be actionable. And it was actionable because there would be a specific statutory command requiring an agency to act by a certain deadline. And here we have that command. You declare that ASQ, now go comply with that ASQ. And it has to happen by a certain deadline. It has to happen annually. So I think that example in SUA is actually very helpful. I'm almost out of time. Can I briefly address your reasonable pricing question?
Yes.
So the reasonable pricing question, that really just talks about market pricing, market forces, Your Honor. And if we look at the legislative history, I'm going to refer you to JA 4994 through 95, and I'm going to read to you. The legislative history showed that the parties were familiar with that because something very similar had been used in the Chamberlain-Ferris Act of 1916. And what they said was, we understand it to be timber operators reach a section of ONC timber, which they may cut in their judgment at a profit. They make application for that particular tract to be put up for competitive bidding. They make their bid for it, and it is then put on the market with the resulting sale. It's not difficult. It's simple. It's common sense. It's market forces. It's simply selling or offering timber to comply with that declared annual sustained yield quantity. And I am out of time. If the court has any further questions, I'm happy to answer them. But I would just ask your honors to remember that in 1937, Congress set these lands aside for the dominant use of sustained yield timber production. Dominant use means that conflicting uses are disallowed. And the president and BLM should not be allowed to flout Congress's express intent for these lands. So we would ask you to affirm the district court in all respects, in monument, in plan, and certainly in Swanson.
Are you aware of any precedent that finds an action discrete when it's an ongoing every year kind of obligation?
Your Honor, I think an annual obligation, I can't give you an example. I think an annual obligation probably is not infrequent, and it is discrete.
Okay, thank you.
Any recent examples of a district court permissibly taking control of the agency's operation to its satisfaction to see whether or not they follow the rules in an ongoing way? Is there some authority for that? I mean, I know it happens in some contexts. That's a strange order.
Well, Your Honor, there are certainly cases where courts retain jurisdiction.
Anything that's comparable here, where a district court, this is a regulatory authority, Interior, does its work each year, and a district court judge says, bring it to me each year, and I'm going to look it over and see whether I agree?
Well, Your Honor, in your tract decision, which you authored, there the court retained jurisdiction, required periodic reporting, and you actually said in that opinion that if the parties felt like something was needed to be brought to the court's attention, the parties were welcome to come and petition the court for additional assistance. I don't think it's uncommon to retain jurisdiction and to require periodic status reporting. And in Swanson, the only thing the government really objects to is the fact that the appellees get to comment on those status reports. So the court is not inserting itself into the day-to-day operations. It simply compelled compliance with the statute, and then it stepped back and went no further. Thank you, Your Honors.
All right, thank you. Mr. Todd, why don't you take 2 minutes? And can I ask you, I know one of you all would have told us, but there's been no resolution of the Murphy case out of the Ninth Circuit, is that correct?
That's correct. It was argued on August 30th, I believe, by a colleague of mine who's in the gallery today.
Okay.
We're still submitted. We're waiting for a decision. Judge Henderson, I'd like to start with your question to my colleague, Ms. Boyle, during her presentation, where you asked whether the record showed that from 1937 on, the Secretary had applied the ONC Act for these other purposes, including protecting watersheds. I'd point the court to the 1938 regulation that we discussed in our blue brief, 46 and 47. It said that scenic strips of merchantable timber could be reserved in certain locations, including beside lakes, streams, roads, and trails for those other non-timber purposes. That was part of the exercise of sustained yield very early on. It was the first regulation after the 37 Act was enacted.
What's your response on sustained yield? The question I raised, and counsel on the other side points to headwaters for a narrow definition of it.
So that missed Seattle Audubon Society that grappled with the Northwest Forest Plan and the reserve requirements. And although the ONC Act wasn't at issue on appeal, it was a claim made by timber industry litigants in the district court in the Lyons case, and they just abandoned that argument on appeal. The government won. And that was different from Headwaters because it actually grappled with reconciling the Endangered Species Act with the ONC Act. So that's more on point than Headwaters.
Do you have any answer to the question that I raised? Is there something that tells me what sustained yield means beyond what intuitively it appears to mean from the words of the statute? Is there something that amplifies that somewhere?
We haven't presented in our brief a deep historical dive into, the forestry.
I don't want it to be deeper historical. I just want something authoritative. Is there anything?
We haven't presented anything or found anything.
I know, but that's so strange that all of you have done this. I mean, that's a crucial concept here.
Right.
It's really not terribly well explained by any of you. So if I'm criticizing, I'm doing it across the board.
I understand. And like I said, we didn't do a deep historical dive. But it is a concept from forestry. At the time, it was a conservation concept of foresters like Gifford Pinchot, who saw the federal agencies as stewards of the land management. And so they were protecting the resources in the long term, not just for extraction, but also for preservation. And so you could have that resource intact over the long term. Briefly regarding the monument, my friend Mr. Bechtold made a comment about arbitrary and capricious review or rational basis review. This just highlights, this is a review of a presidential action. You have to look to the face of the proclamation. And Judge Edwards, to address your point, the proclamation makes a bevy of findings about the importance of the region that was declared as a monument. They haven't challenged the monument as violating the terms of the Antiquities Act. It's valid under that statute. And there is, and that's the end of the inquiry in our view. There is no rational basis inquiry, arbitrary and capricious inquiry into the mind of the president. Briefly on I think I touched on the plans. So I'll move on to Ms. Weiss's presentation about Swanson. Judge Pan, I think you have it right. This is an ongoing obligation of the agency to administer the program every year in the same way that you cannot challenge that ongoing program under Lujan. You cannot compel the program to be administered in a particular way under SUA either. So I think for all these reasons, we would ask the court reverse the district court's judgment.
All right, thank you.
Okay. listen. Yes. Even though I the others. So, right, keep saying you do that. Right, I know. No.
Case number 21-1187, Public Employees for Environmental Responsibility petitioners versus Environmental Protection Agency. Ms. Dinnerstein for the petitioner, Ms. Aceball for the respondent.
Ms. Dinnerstein, good morning.
Good morning, Your Honors. My name is Paula Dinnerstein, and I represent Petitioner Public Employees for Environmental Responsibility, or PEER for short. I first want to just tell you a little bit about PEER and why we have standing, and then I will get into the substance of the case, which we believe turns on the fact that the agency advanced impermissible, erroneous interpretations of the governing statute, the Resource Conservation and Recovery Act, or RCRA. So 11 years ago, PEER filed a petition with Dr. Kate Jenkins, who was then an EPA chemist in the RCRA program, asking to amend the corrosivity characteristic under RCRA to cover more wastes, particularly hazardous waste with a pH between 11.5 and 12.5, and also to expand the characteristic to cover non-aqueous, meaning like solid or solid or gaseous wastes. The petition sought to bring these wastes into RCRA's stringent cradle-to-grave regulation of hazardous waste in order to protect human health and the environment. Dr. Jenkins, our co-petitioner, was a leading person in bringing to public attention the fact that the first responders at the World Trade Center disaster were continuing to suffer from illnesses and injuries due to the hazardous conditions there. And that was part of the impetus for bringing this petition, that the injuries these people were suffering were in part due to the corrosive nature of the dust from the explosions, and yet because of the laxness of the corrosivity characteristic, those were not classified as hazardous wastes. So PEER works on behalf of public employees in environmental fields in order to ensure that the nation's public laws concerning the environment and programs are implemented properly. You know, in addition to people like Dr. Jenkins, who is one of our supporters, we also have people, the declarants that we use for standing, who are directly affected by what is considered a hazardous waste. Our declarants either work or live in close proximity to non-hazardous waste disposal sites that would not be able to accept some of the waste that they now accept if our petition were granted. So turning to the merits, the denial of the petition here was not based on EPA's review of technical scientific matters or an exercise of policy discretion that was permissible that would normally have this court give deference to its decision. It was based on these erroneous interpretations of the statute.
Ms. Dinnerstein, it strikes me as, even if we were to agree with you on some of these merits, you have a very steep challenge based on the standard of review.
Standing?
Yeah, no, standard of review. Yes, where someone like your client petitions an agency for rulemaking and the agency declines. My understanding is that this is a deference so broad as to make the process akin to non-reviewable. I mean, the agencies have discretion to decide, how they want to spend their resources, and they just denied your request. And it's not that we're de novo considering whether we agree with you. We have to find that they've really abused their discretion. It's even beyond abuse of discretion. It says we may reverse the agency's choice only for compelling cause, such as plain error of law or a fundamental change in the factual premises previously considered by the agency.
So I would contend that the case you're citing and cases like that are actually distinguishable, because in those cases, the petitioner was asking the agency to regulate in an area that maybe they hadn't regulated in before, or to do something new. And what the court was saying was that the agency has the discretion as to how it's going to use its resources, what it's going to pick and choose to work on. Mm-hmm. This is not a case like that. There is a corrosivity characteristic. It exists. There's no discretion as to not.
Do you have any precedent that supports what you're saying to distinguish the standard?
Well, the precedents that we have will say that if EPA makes a decision like this, not to regulate a waste, and it's based on an improper interpretation of the statute, there is no deference. There's no deference under Chevron, because you're at Chevron step one.
But we're talking about in the context of a request for a rulemaking. Yes. Do you have any precedent like that?
So, for instance, in the case of Hazardous Waste Treatment Council versus EPA, UC Circuit 2016, this was a challenge concerning a listing. And
so what was the name of the case?
Hazardous Waste Treatment Council versus EPA.
Okay, I've got it.
Yeah.
Where are you citing? Where are you citing to?
And there, the court said that the agency came up with all kinds of reasons that it shouldn't be listed, basically policy reasons, adverse consequences. And what the court said is that regardless of whether these are true or not, it's the agency's obligation to comply with the dictates of Congress and ours to enforce them.
Oh, I don't think this was a petition for rulemaking, from what I read.
So another example that is somewhat relevant is the Supreme Court case of Massachusetts versus EPA, where that was a petition to issue a regulation. And although the court recited, that there's a very strict standard of review for a declination to grant a petition, that on the legal issue of whether or not there's authority, statutory authority to regulate in this area, the court did not grant deference. They did the usual, it's the court's responsibility and not the agencies or anyone else to read the statute and determine the law.
I mean, wasn't that a situation where the Supreme Court said the agency mistakenly assumed that they could not regulate in that area, and so the answer they gave to the petition for rulemaking was improper, and they sent it back?
Right. Yes.
That's not this case. I mean, yes, where an agency says we're not going to engage in rulemaking that you've requested because we don't have authority. The Supreme Court said, well, we can look at that, and if you're wrong, and if you really do have authority, we'll reverse it, and that standard review is not so rigid as to knock that case out. I didn't think that was this case here. No, they're not saying they can't regulate. They're saying they already have, and they don't see any reason to change what they've done. I think that's a question.
I mean, it was a slightly different situation, but the point I'm trying to make is that on the legal issues, such as whether there's authority to regulate here, that's different legal issues, the court has the authority and the responsibility to interpret the statute and decide what the statute says. And just because it's a petition that, under a circumstance where EPA, say, had lots of discretion as to whether they even wanted to regulate in this area, but the court is not going to force EPA to choose to do something within its discretion.
Right.
And the Massachusetts case, I also have a quote here from the case where they say, but once EPA has responded to a petition for rulemaking, its reasons for action or inaction must conform to the authorizing statute. And that's what we're saying here, that the reasons for inaction do not conform to the authorizing statute.
Could you address the timeliness of your claims specifically?
Yes, so the EPA argued that our complaint was not timely because we were challenging certain things that were decided in 1980 when the original regulation was promulgated. We contend that that is not true. What they say is that, for instance, when they promulgated the regulation, they decided that because of the RCRA definition of hazardous waste, which says that a hazardous waste is one which may present a hazard to health or the environment when improperly managed, that therefore they could take that word managed and run with it, so to speak, and say that they could consider any management considerations, and that even if a waste otherwise complied or fit within the definition of a hazardous waste, they could say, well, we're not going to call it a hazardous waste because we're making a management consideration that this waste has a beneficial use and we're not going to regulate it. Now, EPA did not say that in 1980. What they said in 1980 was that, well, we think that the standard, the 11.5 pH standard, is unnecessarily conservative. The basis we have in the International Labor Organization Encyclopedia says 11.5, but we're going to make it 12.5 because we think that's unnecessarily conservative. And the encyclopedia applied to eyes and not skin. When it came to the time to deny our petition, they abandoned that rationale. So the statutory rationale that they have, and which we say is impermissible, now wasn't made in 1980. In addition to that, they, even if you were to say that they did consider some of the same things in 1980 as now, we think this is a clear case of reopening. They considered this petition for 10 years. They considered hundreds of documents. They came up with statutory interpretations, some of which I'm going to go into in addition to the one about the definition of hazardous waste that were not in the 1980 decision. They considered many, many more studies.
May I ask you about?
They came up with a new decision.
May I ask you about language in the 1980 decision that seems to suggest that they did consider management? It says all advocated, including solids in the corrosivity characteristic, but none describes situations where the improper disposal of such waste would be likely to cause damage.
I'm sorry, I didn't hear the last one.
Would be likely to cause damage. Improper disposal would be likely to cause damage. Mm-hmm. So aren't they relying on management of waste?
They did rely on management of waste, but they didn't give a statutory basis for that like they did in 1980. So what we're challenging here is that they actually changed their rationale from 1980 until the petition denial in 2021. In 1980, they just said it was too strict, and they said the ILO encyclopedia only applied to eyes and not skin. They're not saying that anymore. They have omitted ILO encyclopedia, which is what they base the standard on, says 11.5. Anything above 11.5 is going to cause damage to skin. But then they're bringing in a new...
Wait, so to make sure I understand you, yeah. Are you saying that they did rely on the same rationale in 1980, they just didn't cite a statute, and then they relying on the same study, the ILO, but they're emphasizing a different part of it? And to you, that's a change?
No, what I'm saying is that they did not have the statutory interpretation that they have now back in 1980, which is what they say is time barred. Their brief claims that their statutory interpretation of the definition of hazardous waste is what was decided in 1980, and therefore it's time barred now. But that is not what they did in 1980.
I understand your position. Thank you.
So,
Let me ask if there are any more questions, because you're over your time. But, okay. We'll give you a couple minutes in reply.
right, so
No, we'll give you a couple minutes in reply.
thank you. So the statutory misinterpretation.
Mrs.
You're
Henderson,
out
Yes,
of time.
you're out of time. We'll give you a couple minutes in reply after Ms.
Oh, I'm
Isbot.
sorry. I misunderstood.
That's okay.
Thank you
No
very much.
problem.
May it please the court, Sarah Isbert for the United States. With me at council's table is Susan Johnson from EPA's Office of General Counsel. The inquiry before the court is a narrow one, and Judge Payne, you honed in precisely on the points that I'd like to make, which is the inquiry before the court is whether EPA erred in denying Pierre's rulemaking petition. Under this court's precedent, EPA's denial is afforded significant deference. Pierre seeks a rulemaking to revise the corrosivity characteristic by lowering the upper threshold of what's classified as corrosive from a pH of 12.5 to 11.5, and by including non-aqueous waste. Pierre bears the burden of proof in this instance, a burden that it has not carried. The corrosivity characteristic was issued as part of a 1980 rulemaking that established a broad-based program and framework for categorizing and managing all hazardous waste. That regulation was just one of many regulations issued during this rulemaking, and for over 40 years, it has functioned as intended to address the risks posed by hazardous corrosive waste to human health and the environment when such waste is improperly managed. In evaluating Pierre's rulemaking petition, EPA was focused on the relief that Pierre requested, a revision of the corrosivity regulation, and looked specifically at whether there was a gap in regulation that granting Pierre's petition could address. In other words, EPA looked at whether wastes not regulated under the corrosivity standard were causing injuries that could be addressed for EPA to lower the upper pH level and include non-aqueous waste. It didn't consider non-corrosive injuries, nor did it consider injuries outside of the waste management context. This focus was consistent with EPA's longstanding practice, the objective and purpose of RCRA, and made practical sense.
All right, Mrs. Hart, you need to not read
Don't
because we
read.
have a rule against reading.
Okay,
Talk to us.
sorry about that. I'm going way too fast. So EPA
You want to
carefully...
start all over again? We missed everything. No, I'm just kidding.
So EPA carefully considered Pierre's petition and reviewed the study cited. EPA also looked at new information and damage incidents that had arisen since the 1980 rulemaking. It considered the data and proposed a denial that addressed.
Isn't this a reopening case? You essentially, not on the very initial determinations, certain initial determinations, as you concede in your brief, but you gave new rationale for some things and you went into some things in great length. So aren't you beyond that state farm standard review, which is very, very favorable if it's just we'd like rulemaking? It looks like you reopened some matters on your own initiative.
No, Your Honor, I would disagree that EPA reopened. There's 4 aspects that we claim are time barred in Pierre's petition for review. And in those 4 aspects, EPA did not undertake any sort of substantive reconsideration, which is what's required for reopener. So the first is EPA's statutory interpretation of the definition of hazardous waste under 42 USC 69035. EPA has, since the 1980 rulemaking, traditionally relegated the paragraph B for regulating most waste, including the characteristics of hazardous waste, such as corrosivity, but also the other characteristics like ignitability, reactivity, and toxicity. And that was clear in the 1980 rulemaking. If you look at JA4, which is the final denial, there's a footnote which quotes from the original rulemaking, and EPA lays out its statutory interpretation there. There was no reopener because EPA merely restated its statutory interpretation
I thought you gave some new rationale at some places.
I would disagree that there was a new rationale. This isn't a case in which there's a gap in regulation. And what EPA did here was look at whether there was new information since 1980, since the 1980 rulemaking, to support a revision of the corrosivity regulation. It undertook its own review, which it wasn't required to do, but it looked at the information that Pier supplied since 1980. And in support of lowering the pH, Pier relied primarily upon global guidance that EPA found was neither binding nor directly relevant. And in support of including non-aqueous waste, Pier relied primarily upon evidence of damage from the World Trade Center attacks, which for a variety of reasons, EPA did not consider a plausible waste mismanagement scenario that RCRA was designed to address.
Now, it sounds like the answer you're giving to the Trade Center is we're not really sure, so it doesn't fit the normal mold, so we're not going to treat it as if. There's no definitive science on that, as I understand the record. On the rail train, where the dust from the World Trade Center.
So EPA
is not saying, look, there's a definitive scientific answer on that. That's not what I understand.
Yeah, I think that's correct, Your Honor. I think EPA was unable to draw a causal connection between corrosive properties in the dust and the injuries that were suffered. I think EPA would acknowledge that there were definitely adverse health effects. I mean, the World Trade Center cough is a very famous phenomenon, but that is not necessarily a corrosive injury. That's more of an irritant respiratory type of injury, which is what the corrosivity characteristic was not designed to address. But going back, I want to go back to what the time-barred aspect and the reopener arguments, because I just want to clarify that EPA does not contend that all aspects of Pier's petition is time-barred. EPA recognizes that Pier, under RCRA, has the ability to petition to revise the corrosivity characteristic. There's no question under the statute. But there is a statute of limitations in RCRA under 42 USC 6976A. And the time to challenge the original 1980 corrosivity regulation has passed. So to the extent that Pier seeks to revise the corrosivity regulation, EPA tailored its review to whether there was a justification based off of information that had arisen or information that was not available at the time of the 1980 rulemaking. And to the extent that See,
the statute says that any person can petition for promulgation, amendment, or repeal of any regulation.
Yes, Your Honor.
And the agency, and I can't remember how many statutory provisions are written that way, but in any event, yours it's broad. And you responsibly, over a decade, that's a little bit long, answered fully. And you gave a full answer to all of the related questions. Can we judge you on your answers? You're not suggesting we can't, if you say something in your response that makes no sense, it fails review that we are entitled to undertake. Can we not comment on that?
EPA's final denial is undoubtedly judicially reviewable. EPA does not dispute that. But to the extent that EPA simply explained its statutory interpretation, did not reconsider it, did not change it, did not withdraw it in any way.
And when you say that, do you mean to say to the extent that we simply repeated the words, even though we may have changed them a little bit, that we used in 1980, you can't judge us? Is that what you mean to say? Because I think you did more than that.
I don't think that EPA did. EPA looked at the new incidents and said that this corrosivity characteristic is properly regulated under 42 USC 6903, the subparagraph B, which allows EPA to consider the risks posed when improperly managed. And that interpretation and that corrosivity should be regulated under subparagraph B, that was set forth in the 1980 rulemaking. And EPA did not revisit that. This case is more like the ARTBET case that we cited. It's the American Road and Transportation Association case, where the court found that reopener did not occur if the agency was simply restating its statutory interpretation and applying it.
Well, that's the question. I mean, it's close because there's some places I think the agency's trying to be responsible. You're stating a lot, and that it looks like more than just restating.
Right, and I think the ARTBET case recognized the difficult position that the agency is put in, because if it does a really comprehensive job and thoroughly responds to the comments, which is what it did here, it's subject to a challenge of reopener. And if it doesn't do a good job, then it's subject to challenge under the APA for its treatment of the petition for a rulemaking. I mean, I don't think that the fact that EPA did a good job and responded to all the comments is evidence of reopener. It's simply evidence that EPA complied with its obligations to respond to the rulemaking petition. I see that I'm out of time, so I just wanted to underscore that EPA has a significant amount of discretion here when it comes to the technical determinations it made and its review of the scientific data. It also has a lot of deference when it comes to deciding whether rulemaking is appropriate. This isn't a situation where there's a gap. This is a situation where the regulation has functioned as intended. So unless the court has further questions, I would urge you to deny the petition for review seeking a rulemaking petition.
Thank you. Ms. Marsh, okay, why don't you take 2 minutes?
So first of all, I just wanted to make clear, in case I hadn't before, that the statutory interpretation of the 6903 A and B that EPA made in 1980 was not the same as what they made in 2021. In 1980, they said A applies to substances that are hazardous no matter how they're handled. B applies to substances that can be hazardous if they're improperly managed. And they even said in the rulemaking that B covers far more substances than A. It's much broader. When you come to 2021, they're using B to contract the area of regulation of hazardous substances, saying because the word management was used in the statute, we can consider any waste management considerations we want, including ones outside of the statute, like our desire to allow hazardous waste, certain wastes, such as the waste from waste treatment plants to be allowed. And therefore, we're going to set it on that basis.
Ms. Dinnerstein, looking at the 1980 rule, it does say, and I can see this is under listing, it does say here that it is EPA's conviction that most wastes are hazardous only because they pose a substantial present or potential hazard to human health or the environment when improperly managed, and thus meet Part B of the statutory definition of hazardous waste.
Yes, that's correct. And we actually agree with the interpretation they gave in 1980. That's the correct interpretation. In 2021, they added to the hazardous waste definition, but we can exclude things because we think that some of these wastes are managed beneficially. That's not the same interpretation. They gave a new interpretation in 2021.
But it does say, if I may, I'm sorry, yes. It says EPA nevertheless recognizes that there are wastes which are so acutely hazardous that they can be considered to present a substantial hazard, whether improperly managed or not. So okay. Aren't they, I guess I'm not understanding what the difference is between what you think they said in 1980 and now, because it seems they were always focused on management.
They said there are some wastes that come under A that are hazardous no matter how they're managed. Mm-hmm. Then there are some wastes that come under B, which is much broader, that become hazardous if they're improperly managed. Yes. So that's the correct interpretation of the statute.
And so what's different now?
But what's different now is that in 2021, they rely on B, which has to do with the improper management, to say that because it is about improper management, we can consider what we call management considerations, which is not even about improper management. It's about, we think that some of these wastes are beneficial and shouldn't be regulated as hazardous, and therefore we're going to set the characteristic to exclude them.
I see what you're saying. But they relied on that in 1980 with respect to the lime sludge.
No, they did not. In 1980, what they said is, we want to exclude lime sludge, but they didn't say it was because of their interpretation of A and B. They did not rely on that part of the statute or any statutory interpretation to do that. They just said, we think it would be too strict and we want to exclude this waste.
Yeah, but on what authority were they doing it in 80?
They didn't really have a good authority. That's part of the problem.
You just said you agreed with their interpretation.
I agree with their interpretation of the statute, which wasn't even in the part of the regulation that had to do with the corrosivity standard. It was in another part of it. They interpreted that part of the statute, and we believe they interpreted it correctly. It had nothing to do with the corrosivity characteristic in the 1980 ruling. It's in 2021, they come back and say, we did this in 1980. They actually didn't. They came up with a new interpretation of what the meaning of hazardous waste that allowed them to deny the petition because they wanted to exclude certain waste from regulation. So I see that my time is out. I did just want to talk about the other statutory misinterpretations.
If my colleagues don't
you would
have
like
any
to hear
questions,
that, I'm
if
sorry.
my colleagues don't have any questions, we'll get that from your brief.
Okay. So if there are no further questions, are there? Then thank you for your time. I appreciate it.
Thank you.
And just in conclusion, we contend that the petition denial needs to be vacated because it is based on impermissible statutory interpretation. Thank you.
Thank you. Thank you.
Okay.